This is all the shit we're not supposed to see or read. You'll see. I'm going to make a way longer video, but this is just a taste of what this court has become.
2023, and it does appear to be in the amount of 3,000 professional surety.
Executed December when?
This guy in the background is a fucking hero, but we just can't get into that right now. We need to watch this guy.
December 10th of 2023.
All right, and that would be consistent with the offense of December 9th. Deputy, you were going to say something?
Yeah, so they do have the one for the 12/9.
Okay, and they
The
have
print. He was arrested that date, and they photographed and printed him, and he posted a bond at that time.
Okay, so Mr. Regier, you have what you need to turn this over to the KBI for disposition at appropriate timing. Sounds like you've got your sheets that just the numbers tracked to the KBI to show that he was arrested, that he will have a disposition, and you can send the papers in then.
Your Honor, at this time, I have not seen any paperwork as far as booking and processing is concerned, only that prior to the information being filed with the court, I am showing that an appearance bond was executed in this matter.
All right, so all you have is the bond. Deputy, you know the paperwork I'm talking about that goes in with the fingerprints, KBI and the FBI. We used to call them the old green sheets.
You talking to me, Judge?
Yes. Can you just make sure that all the legal paperwork that gets this to KBI and FBI is submitted properly?
Okay, well, tell the jail.
All right, thank you. Sounds like maybe Mr. Regier didn't get that. Sounds like your client has done everything he needs to do, Mr. Smith.
Appreciate it, Judge. And I will say one more thing on the topic, if it pleases the court. Any issues there may be with compliance with state statute, I will certainly assist in making sure we're able to get those. Since he is pretty far away, we certainly could reach out to a local sheriff's department and have them do any processing in that area. I understand it's a little uncommon, but not unheard of. So if there is any issues, I would request someone please let me know, and I will certainly help and remedy that.
All right, there you go. Deputy Caulfield, are you still with me? Have been misled, if you will. But in any event, I'm going to set this over to April. Do you want a jury trial or do you know yet?
I have no idea until I review the discovery, Your Honor.
Well, he asked for a jury trial as early as September 23rd. And then we had the pre-trial, as counsel said, on February 3rd.
At this point, I think a safe thing to do would be leave that in place until and unless I have authority to waive it in his behalf.
All right, so Jen, did we put that down for pre-trial and jury trial in May?
No, at the time of the hearing, we did not.
All right, let's do that. The pre-trial date, Mr. Jensen, is, Jen, would you remind me?
Sorry, Your Honor. May 19th is pre-trial.
19th pre-trial by Zoom, and then jury trial May 21st?
21st and 22nd.
All right. Now, for speedy trial purposes, we had first appearance January 8, 2024. And we set it over to March 18th to give defense and his attorney time to look into diversion. Bond was continued. And so that I would find counts against the defendant. Then that was set over then to May 13th, still applying for diversion, but it was denied. That's when he finally got Patterson appointed. It was May 13th of 24. And it was set over at the defendant's request to 7:15. The defense had not had time to speak to the defendant. The attorney had not. And the defendant requested a continuance. So we set it over at defendant's request to September 23rd. Patterson and defendant present, and that's when they asked that it be continued for jury trial. And it was continued to the pretrial May 3rd, as well as the jury trial. And then at the February 3rd hearing, Mr. Patterson asked to be removed due to the defendant not being indigent, and that was granted and set over to today. So far, I'm finding all continuances are at the defendant's request. Speedy trial time to count towards the defendant. And I'm going to count this time to the defendant, because had he not created the issues with indigency and asked for a jury trial, and then he wasn't ready for a jury trial, and his counsel was asked to be removed. So until May 19th, and that's when I'm going to show that all of that time basically counts against the defendant, unless Mr. Jensen, if you want to be heard on that, or we could revisit it the next time, since you haven't really had time to go through all this.
Your Honor, I already have one matter on the May 19 and May 21 dates in your court.
Jury trial.
Add this to that, and if something arises, I will promptly notify the court and counsel.
All right. Thank you very much. If there's nothing further, the defendant is continued on his bond. And I'm going to have to take just a minute since Missy's not here to help me, I'm going to have to try to figure out what to do with my screens that have gone black, as you know they tend to do. So give me just a moment, please. Someday I may get a different system here to work from, but not holding my breath. All right, we will be in recess. Mr. Jensen, your client is excused, and you're excused unless you have someone else.
Your Honor, I do have one other matter, I believe.
All right, who would that be?
Mulvaney, Chase Mulvaney, 24 CR 351. Is that on the court's docket?
It is. I just didn't note that. Let's see. We are on the record in 2024, CR 351, State of Kansas versus Christopher Chase Mulvaney. Please announce appearances.
Forgive me, Your Honor, I appear to have been previously muted. Jared Regier on behalf of the state.
Gail Jensen for Mr. Mulvaney. Your Honor, the reason why I was concerned about whether it was on the docket was that I was advised this morning that when Mr. Mulvaney contacted the office, it was perceived that he was not going to be necessary because we hadn't received his present. We weren't going to be able to proceed because I hadn't heard back from Mr. Regier on a settlement offer that I'd made last week, and we had also just transferred over the evaluations for Mr. Mulvaney on the 29th of November, I believe. Excuse me, of January. So I'd ask this be set on the 7th, so Mr. Regier can respond to the offer I made, and we can proceed at that time.
So did I understand correctly? Your client is not here?
He is not. But I think that's because of confused status on whether it was a city matter or a county matter from my office.
I see. Well, November 25th, the 24, you and the client were here, and we sent it over to today.
Yep.
Mr. Regier, your response, this happened allegedly July 28th to 24. Possession of firearm under the influence of alcohol or drugs, count 2, DUI second, and count 3, defective tail lamp on a motor vehicle.
Your Honor, under these particular circumstances, the state would not object to setting this matter over if the court is continuing the bond in this case. The state, however, would request, if this is not the inappropriate forum to make such a request, that counsel for the defense re-provide the drug and alcohol evaluation It is the state's understanding that a document of some kind was provided by counsel to my office. Unfortunately, I have not been able to obtain access to it.
Okay, the note I have on my calendar is that it was forwarded on the 27th to the court and on the 29th to the county attorney's office of January. I will follow up on that immediately.
Very well. I will continue this at the defendant's request to April 7th at 9 a.m. The bond will be continued with the added condition that he reappear with counsel by Zoom at that time. With it being set that far out, hopefully we can reach some kind of resolution at that date and time. So anything further, counsel? Mr. Jensen?
Not at this time. Thank you, Your Honor.
Welcome, Mr. Regier.
Nothing further from the state, Your Honor.
Well, then we are in recess. Mr. Jensen is excused.
Thank you.
And Mr. Andrews?
Yes, Your Honor.
Pick up, do you have any besides Teague?
I have Preston Durrat, Your Honor. If we could take him up first.
Okay, let's take him up. We are on the record in 24 TR 801, State of Kansas versus Preston Blake Durrat. Please announce appearances.
Chair Regier on behalf of the state.
Joshua Andrews on behalf of Preston Durrat, who is also present for the Zoom call.
And how does he wish to proceed on this driving while suspended second charge?
Your Honor, we have entered into a plea agreement with the state. Mr. Durrat will enter a plea of guilty to the sole count of driving while suspended second offense. There will be a joint sentencing recommendation of an 8-month controlling sentence with 120, 8-month controlling sentence with 12 months non-reporting probation, a 10 days house arrest, $100 fine, and court costs.
That's your agreement, Mr. Regier?
Your Honor, in this particular case, the state is prepared to proceed in that fashion.
Very well. Mr. Durrat, how do you plead to the sole count of driving while your license was suspended after prior conviction for the same?
Guilty, Your Honor.
And by pleading guilty, are you admitting that you did drive while you were suspended after a prior conviction?
Yes, ma'am.
Is anyone making you enter this plea today by threats or promises other than
No,
your
ma'am.
plea agreement? No? You understand you're giving up your right to trial. You'll be found guilty and not able to appeal that conviction?
Yes, ma'am.
All right, and were you driving in Butler County on December? Just a moment.
Your Honor, I show December 19, 2023 in the information.
And is that when you were driving, Mr. Durrat, in Butler County?
Yes, ma'am.
And a Deputy Andrew Peniston has filed an affidavit alleging that you were southbound on Southwest Santa Fe Lake Road, passing Southwest 40th Street in Butler County when he observed you driving a black GMC Suburban. Would you agree that that's where the officer would have stopped you or thereabout?
Yes, ma'am.
And did you have a prior, was your license suspended at that time?
I thought it wasn't because I paid off all my fines, but evidently it still was.
All right.
I thought once I paid my fines off that it just went to not having a license, but I was wrong.
Okay, so you've since found out that you were suspended?
Yes, ma'am.
And did you have a prior conviction for driving while suspended?
Yes, ma'am.
Would that have been in Butler County District Court case 22 TR 3565?
Yes, ma'am.
All right, I accept your plea and find you guilty of driving while suspended after a prior conviction. I will follow your plea agreement. You are fined $100 and assessed 108 court costs. How much time do you need to pay? $208?
30 days if I can get it, Your Honor.
You can get it 30 days to pay. You will be sentenced to 8 months in jail, but you won't have to serve that as long as you successfully complete a 1-year non-reporting probation. So for 1 year, you are on probation. You do not report, but you are ordered not to violate any laws during this time. You are ordered to pay $208 within 30 days, and you are ordered to do 10 days house arrest. You are to start that within 7 days. You are to provide proof of completion to the county attorney and your attorney.
Okay.
Do you have a job?
Not currently, Your Honor.
All right, you are not to leave your house under any circumstances except for absolute medical emergencies for 10 days. You'll need to contact the electronic monitoring to make sure you're wearing that monitoring device within 7 days for a period of 10 days.
Yes, ma'am.
All right. Mr. Patterson, do you have the number memorized for electronic monitoring?
I believe I have that on my computer right now, Judge.
I know you're not his attorney and I'm kind of
Sure.
putting you
The
on the spot there, but sir, write this number down.
phone
ma'am.
number is